One mistake can change your life forever. If you or a loved one is facing a felony DUI charge in California, this information will help you. Hi everybody, my name is Stefano Malea. I'm a California criminal defense lawyer and I've been so since 2011. And today I'm going to tell you some things that will help you or a loved one deal with a felony DUI charge to make sure that your rights and your freedom are best protected. So let's talk about how you can be charged with a felony DUI. Well, the first one is if you're driving under the influence and somebody gets hurt as a result. That's DUI with injury. The second is if you've got 3 previous DUI convictions, your 4th one can be charged as a felony. And then finally, if in the past you've ever been convicted of a felony DUI, any DUI after that can be charged as a felony. So you're on the side of the road, the cop's shining his light in your face, and you're stressed. And this police officer asks you to conduct field sobriety tests, to participate in these field sobriety tests. Well, guess what? Even if you're like, hey, you know what? I'm fine. I had a beer or 2. I can do these tests. I'm athletic, whatever you think, right? You may have a lot of confidence. The bottom line is you're gonna be on the side of a road. You're gonna be intimidated by this cop. You're gonna be stressed out, and you're going to be asked to perform these tests that are extremely difficult, even if you're sober as a bird. These tests are so hard to pass. And so the bottom line is anything that you do is gonna be used against you. So bottom line, don't take any of the field sobriety tests. Don't answer any questions related to where you've been, where you're planning on going, what you had to drink, what you had to eat, any of that. Just remain silent and assert your rights. That will help your case. So next, despite the fact that you've done all the right things, you haven't answered any questions, you have not participated in any field sobriety tests, maybe the cop thinks you have red watery eyes, maybe the cop claims that there's slurred speech or something like that, unsteady gait, all the usual stuff. They decide that they're going to arrest you for driving under the influence. Once they do that, once they've told you you are now under arrest, you're in handcuffs, you're in the back of the car, they're gonna read you something from a DMV form. And essentially that's gonna tell you that now that you've been arrested, you are required to either take a breath test or a blood test. And only if those are not available, then a urine test. Now, in this situation, you have to take one of the tests and you have to select one. If you don't, there's a couple implications that you need to know about. The first is that the DMV is going to suspend your license for refusing to take a chemical test. That's not good. The other side of it is that even if you refuse to take a test, the cop's gonna easily get a warrant and then force a blood draw. They're gonna get the results anyways. Now, the bottom line here is that you wanna be friendly. You don't need to talk about things. You don't have to disclose anything, and in fact, you should not. But it doesn't mean that you have to have a negative interaction with the cop, because frankly, if there's any chance of them cutting you a break in any sort of way by maybe delaying the amount of time before you take the test or making things easier for you, they're not gonna help you out if you're being a jerk. So just keep that in mind, do the right thing, know your rights, and take the right next step. Before I move on, if you want to learn more about DUI with drugs in your system, we have a whole series on that. So go ahead and click on the link in the description below and you'll learn a lot more information about that specific scenario and how to best protect your rights in your future. Again, click on that link below to learn more about DUIs with drugs in your system. So moving on now to discussing sort of a specific feature of a felony DUI where it's a felony DUI because of injury that's been caused. So one specific element of a DUI causing injury is that the driver, aside from driving under the influence, has to have either violated a law or neglected a duty that caused the injury. So it's not enough that you're just driving under the influence and there's an accident and somebody gets hurt. For example, if you are driving under the influence, but somebody T-bones you and they get hurt, does it make sense that you're charged with a DUI with injury? No. You actually have to have either violated a law or neglected a duty that was the cause of the injury. So your driving history becomes important when we're talking about potentially facing a felony DUI causing injury charge. What's one way that they will investigate this? Well, witnesses for number one. Second is that most of the time, especially in serious accidents, they can pull the black box data, which is a computer in your car that records, in most new cars, that will record the activity of your vehicle prior to the accident. So if you were driving 100 miles an hour and you rear end somebody, guess what? They can pull that data and use it against you in a felony DUI causing injury prosecution. When it comes to building a solid defense and having a solid defense team, a lot of times you will need an accident reconstruction expert when we're talking about a felony DUI causing injury. I can tell you that I've worked on cases in which the way in which the accident happened is in dispute. And one guy's gonna say one thing, the other guy's gonna say another thing, and that conflict makes a huge difference about whether or not the person charged with the crime was actually doing something illegal that led to the injury. And so how do we fight for our clients in that scenario? We bring in an expert who can come in, look at all the pictures, go to the scene, do measurements, pull data from vehicles, measure things, and then using their expertise, be able to determine potentially that guess what? The guy who's accused of causing the accident didn't actually cause the accident. And that's a huge point of leverage for the defense, because it can literally mean the difference between a felony DUI, where someone could be facing prison, and potentially a misdemeanor DUI with much less severe consequences. You have a constitutional right to go to trial. Now, the decision on whether or not you want to go to trial is going to depend on a lot of different factors. It can depend on, obviously, the strength of your defense, the facts of the case, and how those facts connect to the law and the elements. And of course, the determination about whether or not the government can prove their case beyond a reasonable doubt. So, if you decide you want to go to trial, then here are some critical things you need to know. First, you need to understand that the government has to prove every element beyond a reasonable doubt and convince all 12 jurors that you're guilty beyond a reasonable doubt. If they can't, then you're not going to be convicted, and you legally cannot be convicted. When you go to trial, you want to have somebody standing next to you who understands the jury selection process, who understands their audience. For example, in San Diego County, there are 4 different courthouses. And the way that we might want to present a case to one jury pool is going to be different in one part of the county than it is another. So when we're talking about having a locally experienced criminal defense lawyer, that's what we mean. Now, there's an art to putting forward a case at trial. It's about not only arguing the technical legal parts of the law, but doing it in such a way that the jury understands, that they are moved emotionally to agree with the points that you're making. Now, sometimes that can be difficult, but if you know your audience, you can do everything possible to maximize the opportunities available to get the best outcome, which is, of course, walking away without a conviction and hearing those awesome words, not guilty. So when you go to trial, the most important aspect of it is making sure that you have a good rapport with your attorney and that there's all the preparation necessary to make sure that when you walk into that courtroom, your attorney is super prepared and has all the details worked out, and that you, as the client, understand all aspects of it, because ultimately, this is your life. It's your case. And so you should not be walking into a trial where your freedom is absolutely at stake without fully understanding what is about to happen. And it hurts me when I hear from people that they were just dragged around during a trial, during the entire case, without truly understanding what's at stake and understanding how the case is built. And so the most important aspect of going to trial is being prepared, knowing your audience, and making sure that your lawyer can effectively present the facts, the law, and be convincing to a jury of your peers. Being charged with a felony DUI can be very, very scary. It's not only your freedom, it's your ability to go to work, it's your ability to be with your family. Understanding your rights is step one in making sure that if you're ever in that situation, you know how to properly assert your rights to protect your freedom and your future. Do not answer any questions that are asked by law enforcement. They're designed to increase the chances of you being convicted. If they're asking you to conduct or perform a field sobriety test, you don't have to do it. If you're arrested and you're told that you have to take a chemical test, take it, because otherwise you're just making things worse for yourself. Ultimately, you need to make sure that you can control what you can control. And that is making sure that you don't give the government ammunition to help them prosecute you, and having somebody next to you who knows what they're doing and who can help you navigate this complicated process in the way that's going to increase the chances of you having the best possible outcome.